What's up, everybody? Welcome back into another episode of The Lawyer You Know. And we're not talking about Karen Reed today. We are talking about Brian Kohberger. His case is supposed to start for the trial for all of us to watch in August, but the jury selection is only a few weeks away as the court is gearing up. The lawyers are gearing up. We're going to talk about the pretrial hearing. We're going to talk about the defense's very recent motion to continue, which a lot of it is based on the newest Dateline episode, which we are also going to talk about. Some of the things revealed in there, some of the issues potentially. Will that cause a delay in this trial? And of course, answer all your questions. It's been a little while since we talked about this case, so hit that like button. Make sure you're subscribed if you're following this case. Let's get to it. So Brian Kohberger has been awaiting trial for what seems like forever because he demanded a speedy trial. So it seemed like it was going to go very quickly within a few months of him being indicted. But that didn't happen when he waived his right to speedy trial. And they've tried to set a trial date a couple times. They've changed venue, changed judges. And finally, this judge picked a trial date that was not even really within the agreed upon time period, which was this summer by both of the parties. And that gives us an indication of how this judge is going to be, what this case is going to be like. We've seen some similar cases to this and similar judges to this, but we've got to get reoriented with the judge that is going to control his courtroom. It is going to be his way or the highway, and there will be repercussions if you break this judge's rule. That is one of the takeaways I've had from watching a couple of the hearings he's done. But I've also noticed very much, which to me is not really a surprise. You may be surprised at this. I'm not. I'll tell you why. He wants is the wrong word. He is going to make sure that this is a very public trial. He knows the public is interested, and he is not looking to hide or do stuff in secrecy or in the shadows. This is a public proceeding. If the public wants to watch, the public should be able to watch. And you may say that's, kind of confusing for a strict judge. I'm surprised he would want to do that. No, because judges like him, even though they are strict, they are confident. They're usually very competent. They know why they make the decisions they make, and they have proper backing, and they trust their own research. They trust their own decisions, so they don't care who's watching, because this is a trial, and a trial here should be public, and the public interest has been proven to this judge. So we're going to listen to a couple snippets from this pretrial hearing that happened recently, and just so you can get a little taste as to what this judge is like. And I'll summarize some of the other things, but they're gearing up towards trial. Very clearly, this was about a week before the motion to continue was filed. So while Ann Taylor is prepping this motion to continue, they are going through all the processes and procedures of how Judge Hippler runs a trial.
I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial for a couple of reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something.
So that was an interesting take there. He's saying he wants everything to be handled basically in motions in limine. If you know there's a witness who wants to testify about X, Y, and Z, which, by the way, we're going to talk about some evidentiary issues about what came out in the Dateline video or show, whatever we want to call it. And so if you see that as an issue, Judge Hippler wants to handle it in written form, maybe have an oral argument, but he wants to be able to prepare. He wants the lawyers to come prepared. He doesn't want to have long sidebars. He doesn't want to have to stop the trial to argue major evidentiary issues. So to me, I think that's a good way to handle it. I like that. Some judges are like, this is not for motion in limine. We're going to do it during the case. If it comes up during a witness, object to it, and we'll make the arguments there. So it's kind of two ways to look at it. Judge Hippler is on one side of that. Nicola said, don't come at me, chat. I don't like Hippler. I don't, and I can't explain why. If I could give a guess, Nicola, which by the way, do not come after her at all. I want to know this. I want to know how people feel about lawyers, judges, witnesses, the case. I want to know that. That's the whole point of this channel. I can understand why. He's not like a nice guy. He doesn't have like a jovial personality where people are like, oh, I really like him. Sometimes it seems like he's dry. Sometimes it seems like he doesn't care. Sometimes it seems like he's just making quick decisions or is not letting the lawyers be lawyers. So I get that. I understand that. He's not a perfect judge. I think I like a competent judge. I like a confident judge. I would say if I practiced in front of Hippler, there would probably be some friction at times when I want to make an argument, I want to make a record, and he wants to control me or control the lawyers. You have to push back there. And I think Ann Taylor will do that. We'll see how it kind of comes out. But he's the type of judge I would also like trying a case in front of because I would trust him. I would trust him to make the decision that he thinks is the right decision, which is all you can ask for. And I want a judge that's going to make a call and move forward with the call that they make so I know how to act appropriately. And he is setting out all the rules, which I do really like. So I would probably push back on some of the control that he's definitely exhibiting, but I do really like a judge that tells you how he wants it done, and he's going to make decisions and not make you wonder, what is the decision? Is this going to come in? Is it not going to come in? How am I supposed to prepare my case? I also know he's going to hold the other side to the rules. They're not going to be able to bring up brand new undisclosed expert opinions in the middle of trial. I don't think he would go for that.
And so that helps guard against that and minimize that amount of downtime
I'm also going to be able to listen to him on 3 times speed, which is a plus in my book.
that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given.
He does say at a later point, and I like this, all stipulations should be reduced to writing. Not because we don't trust each other in here, just to protect everyone. Because if you guys say you agreed on something and I didn't see it and I wasn't there, it's very difficult for me to force that agreement. So if it's not in writing and somebody backs out on a stipulation, there's no stipulation. I think that's a good point. David Price said, all due respect, judge is not a popularity contest. I agree with you. I absolutely agree with you. But there are some judges that are way more likable than others. That's also a fact. And it can absolutely matter with how you try a case, how it's presented to the jury, and how the jury feels throughout the trial.
I think I'd asked you also to work on instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of.
He's going to explain to them, there are certain parts of this case, you can't say X, Y, and Z because that's not correct. And I kind of like, when we talk about experts, it's like most experts are allowed in. It's like, if you put some parameters, like, I'm not going to let you say this, I'm not going to let you say that because that's not actually true. I like that. I like that. And again, as long as everybody's on the same page and knows what we're doing, that's the best way to do it.
Of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Herwood facilitated the defense viewing it yesterday.
Okay.
It is available for the.
So we know there is a model of the house. The house is destroyed. There will be no jury view, obviously, but the model of the house will be used in the trial. He called it a dollhouse, which I hate, and he apologized for and said, we're not going to do that anymore. We're going to call it the model house. But I think that's an interesting component. Every time we watch anything in this case, just between me and you, it just reminds me there's going to be so much we don't know. There's going to be so much we don't know about this case. This is going to be one that's incredibly eye-opening. Unfortunately, major bummer in my work life. Trial that was supposed to go middle of June, which was hopefully going to be right after the Karen Reed trial, but be done before the Kohberger trial, got continued over my objection until August, which I don't know what I'm going to do. We'll figure it out, right? We'll do something. Maybe I have to take some days off, maybe do a weekly recap for one of those weeks. If I am in trial, it's only a 5-day trial. But I really hope it goes. I really thought it was going to go in June. Is what it is. We don't have a judge like Judge Hippler, unfortunately. This judge just left things open a little too much, in my opinion, and should have denied the continuance, but didn't.
Court's inspection well, if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described, given what occurred there and the victims.
I think a better term is simply a model,
Yes, sir.
rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Your Honor, we did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence of all of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor.
Okay, so we're going to pause it there for a second. I'm going to, Jen, I'm glad you're able to catch it live as well. I'm going to summarize some of what they talk about. They start talking about juror questionnaires, how they're going to be scanned, how they're going to be able to view them, how they're going to do jury selection. They'll scramble jury numbers. So it's not just like whoever happens to be juror number 1 is going to be juror number 1, or just because if they do it alphabetically, it's going to be more randomized. He said, I thought it was very interesting, they're going to follow some of the procedures done in Chad Daybell and Lori Vallow's case, which we followed. And we know those were going to be precedent-setting cases for Idaho. And guess what? We have another high-profile case in Idaho, and that's exactly what's going to happen. There is going to be some connection there. Wafa said, thank you so much for this coverage. During your last Karen Reed video, I asked for more BK coverage and got some hate. I appreciate your coverage. Just was interested in your opinion about the case. Sincerely, your pregnant listener. Put the headphones up to the baby's ears so they hear my voice, and it's something that they remember. That's a thing, right? So yeah, I think people just, when it's a video about a certain trial and people are very into it, it is what it is. I definitely am going to follow Kohberger. I'm very interested in it. I just don't have time to, really, really dig into this during the Karen Reed trial, but these 5 days off. By the way, if you are a Karen Reed trial watcher, some really cool videos coming Friday, Saturday, Sunday, and Monday. So make sure you're subscribed. You're not going to want to miss those, even though there's no trial. But as far as this case goes, so much has happened. So we're going to try to catch up. We're going to try to follow along. Somebody else asked, are you going to discuss the possible delay of this trial? Absolutely. That's going to be the second half of this video. Let me hold that. Canine Lover, I am going to answer that question, just not right now. Dear Peter, you talk at 3 times speed. I'm a 0.90 listener, but I love you the best. That's awesome. Isn't YouTube great that they let us go up and down depending on who we are, however we are, whatever our flavor is, whatever our fancy is, that's what we can do. Chris K, did you watch the part of the pre-trial? I can stop you right there and say yes, because I watched the whole hearing about juror strikes. From the hearing, it seems like you can't backstrike jurors. Judge said you waive peremptory challenges if you pass on a panel twice. This is a great question, Chris. And as my co-host of the show today, it seems like you give me the perfect transition into the next clip we want to watch, which I will explain what backstrikes are, how they're doing it pretty differently in this trial, and whether or not I would like to pick my jury this way.
And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between. Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those.
So first off, that's interesting, right? You get these peremptories, I think he said 12 each, but he said you have 30 minutes to use them. So, and the way he explains it now is it's like a chess clock. Have you ever played chess with a clock or watched, what was that show on Netflix during COVID that like blew up? Where you're playing chess and you make your move and then you hit the clock and the clock stops. And then it keeps going and then you hit the clock again and the clock stops, because sometimes lawyers take forever. There's a lot of strategy. I like the strategy. I'm a strategic thinker. I think that's, one of my strengths. I love playing games that are of strategy. I'm very competitive when it comes to that. But what I think is cool is like you're making it so you can do your first couple quick. If you want to strike people, you can do 10 strikes in 3 minutes. Then you have 27 minutes for your last 2 strikes, potentially. Queen's Gambit. Yes, thank you. Chat's the best. And that's kind of cool, right? So you can use strategy on when you're going to strike and when you hit that timer and your timer stops and their timer starts and you go back and forth. And he said usually he only gives 1 minute per preemptory challenge, which again, I've never had a judge do something like this. I think it's interesting. I don't know how I would like that part, but I would absolutely hate the next part we're going to talk about. Whoops. Yes, I saw the motion continue. We are going to talk about it and break it down on this video.
It's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything.
He's like, all these lawyers, that makes it easier. I actually like when judges do that, because if you're going to have all these lawyers involved, use them and let's make it more efficient.
If you both pass on a round,
here's the part that I don't like. It started out with if you both pass on a round, meaning I'm good with these jurors. You say you're good with these jurors. We're good with these jurors.
Say the defense passes at the end of round 4, and then the state passes at the beginning of round 5. That ends the use of peremptory challenges, because you both have said to me by passing consecutively, there's nobody that you want to strike. So understand that that rule as you go in.
So that means we pass, you pass, it's over. That's our jury, which is very nerve-wracking for the state who's probably going to go first, because if you like somebody that's like the next one and you're going back and forth and you're hoping the defense strikes them, but they don't, because there's some that we're not sure. We're like, is the defense, or in my case, plaintiff defense, or in a criminal case, if I'm the defense attorney and there's a prosecutor, It's like, maybe if we don't strike them, they'll use one of theirs, get somebody we don't want on the jury, and we can use it to strike a different one. And you have some strategy behind it. Well, that's out the window now, because if you pass and they pass, you're screwed. You're screwed. And when it comes down to picking a jury, that is the most important part of trial. So no striking, I don't like. I think we've had case law that we've argued that you almost have to allow backstriking. And this is one of those positions. Again, I don't know in Idaho if this is just normal, but if he was a Florida lawyer, we'd have some pushback. We'd have some friction here, as I call it. And I may lose the argument, but I would definitely make the argument. I would like to backstrike. Let's backstrike. What is a preemptory strike, please? Great question, Lori. So strikes for cause are when somebody says, I think that dude's guilty no matter what anybody says, he's guilty. That's a strike for cause because you're not fair and impartial. You can't come in here and handle this case as a juror. A preempt, that's a cause strike. So cause strikes are people cannot be fair and impartial, or a cause strike can be for a hardship. I am flying to Greece the second day of this trial, so it's impossible. I have a prepaid ticket. Cause strike because they can't do it. Preemptory challenge is for any non-discriminatory reason. So I can't say, I'm going to strike you, Lori, because you're a woman, but I can say, I'm going to strike Lori because she's a teacher and I think teachers aren't going to like Brian Kohberger. Whatever, right? It can be for something like that. Or Lori looked at us kind of weird. I don't think she likes us. We're going to strike her. Literally, you can strike somebody for that with a preemptory challenge. It just can't be for a protected reason. MB, will you talk? Light most favorable to the state, high level overview. I think we lay people forget that's the starting point. Hit the like. The starting point is the presumption of innocence. The starting point is Brian Kohberger did not do this until and unless the state can prove to us that he did this. That's how we start the trial. Wafa, question. Why is it that Karen Reed lawyers are able to bring up the third-party culprit, but this judge is pushing the defense on the third-party culprit? Baby's due in August. Can't wait to listen to your coverage during the newborn phase. That is the best. I'm jealous. I love newborns. I love newborns. The smell, the feel, the cuddles. It's the best. I'm jealous. I wish I was sitting back and just watching YouTube with a newborn. So I don't know. I have to look into the third-party culprit stuff with this case. I don't know if they have nothing. If they have literally nothing, by the way, it's a little judge to judge, right? And Canoni is even letting some, but not others, and letting some argument, but not certain arguments they want to make. It really is judge to judge. And I don't know what all they have on a third-party culprit. We know a lot more about what they have in Karen Reed on the third-party culprit. I think that's it. Let me just see. There's a few more seconds here.
After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors and the
And that's what I wanted to hear. So in some trials, you pick 12 jurors and then 6 people you pick as alternates. You have strikes for the alternates. In other cases, you pick 18 people and you figure out who the alternates are later. No arguing an opening statement. Obviously, he'll hold you to the time on openings and closings. Pretty strict rule with the PowerPoints. Turn them over to each other. They're going to have time kind of before they start and after they end every day. I think he said 8:45 to 3:30 where they can handle their issues. So don't bring issues up during trial. Only the lawyer handling the witness can object and make the arguments for evidentiary issues of that witness. And only those lawyers can come up and speak during sidebar. I don't like. We've got a team. He's hired a group of lawyers. But on the same time, I get where he's coming from because each lawyer should be able to be a lawyer, right? Experts are going to be able to sit in on other experts. It seems like lawyers are responsible for telling their witnesses what's limited out, what they can't talk about, what's inadmissible. I like that rule. That always is just the norm, but some lawyers seem to forget that. He says he rules really quickly, so you can ask for a sidebar if you want, but basically don't do it too much. Anna said, it seems like he's trying to avoid everything that's happening in the Karen Reed trial, potentially. Jordan said, unrelated, but you ready to put some respect on the Pacers' name? I got to be honest, it is shocking. It is shocking. I still think the Knicks are going to win, and even if they do, I think OKC is going to thump either of them in the finals. We'll see. We'll see. ID has journalist shield law signed March 25th. If Dateline got leaked info before, can they be compelled to reveal source or be held in contempt? Even I knew while watching, sharing more than unsealed would be trial problem. I don't know. I would have to look into that. I honestly, I would have to look into exactly how that works, what the laws are and how they relate to that. I am not positive. Okay. That's it for that part of the hearing. Let's talk about the motion to continue. We're going to weave in some stuff here in the motion to continue. So Brian Kohberger wants to continue. It's not a real surprise. Ann Taylor has always kind of indicated and shown that this might be something that she wants. A lot of it, he says, is he's got to go through discovery, prep for the sentencing and penalty phase. There's so much going on there, mitigation defense, experts, et cetera, et cetera. I kind of think the judge might say no to that. He really doesn't want to continue the trial. I think you're really going to have to convince him as the defense if you want him to get in a situation where he is going to agree that there's too much work to be done because they've already had a continuance and he doesn't want to have any more. And he even gave them more time than when they kind of agreed they would start, which would be at the beginning of the summer. So I think he wants to do everything he can to not continue this. However, let's take a little listen to a minute from Anjanette Levy's podcast about what Judge Hippler is doing about this Dateline NBC Brian Kohberger, which I think this is the episode. I'm not positive. My cat's name is Karen. I assume you know, that's why you put it up there. But I did watch it. I watched it on YouTube TV. I think you can watch it on Peacock as well. But let's take a listen to what Judge Hippler thinks about the information that was shown on Dateline and maybe leaked and how that could be problematic and what his view is on it, because guess what? He tells you what he thinks.
And that one just deals with the state. I will get you one that deals with your side to preserve records. All right.
So Judge Hippler is putting it on Prosecutor Bill Thompson to initiate the process to appoint a special prosecutor to investigate the source of the leak. The order from Hippler.
So before we read the order, that's the judge telling the prosecutor to appoint a special prosecutor, meaning outside his office, to investigate basically his side. I guess it could be the defense, but the defense is the one complaining about the leak and Dateline and the information revealed on there. But so they're saying it's the other side. And so Bill Thompson could be appointing a special prosecutor to investigate his own side, his own team. How about that? Judge Hippler doesn't care. He's not happy. And he does not like the fact that this leak happened. Let's listen to her read his part of his order.
Hippler states, based on sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case and the defendant Brian Kohberger, it appears likely that someone violated the court's non-dissemination order.
It appears likely that someone violated the court's non-dissemination order.
Violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury and will likely substantially increase the cost to try this case by extending the time it will take to seat a jury and potentially requiring a lengthy period of jury sequestration. Hippler.
Those are some words you do not want to hear as a juror and even as a lawyer, because we know it's so much harder to pick a jury when they have to be sequestered. It is so much harder. They are so much more annoyed at everything that wastes time or takes forever. They are so much more annoyed if you have to miss half a day or end early or start late on a day if they are sequestered. But he said, you're going to cause us so much more time and money if you keep leaking it, because we may not be able to pick a jury at all. More on that later from the defense. And we might have to sequester them. You know how expensive that is to get all these people hotel rooms for an entire trial? That's wild.
And potentially requiring a lengthy period of jury sequestration. Hippler said the leak frustrates the ability of both sides to receive a fair trial. Hippler continues, accordingly, the court finds it is imperative to attempt to see that the source of such leak is identified and held to account, and that doing so is the best deterrent to future violations. Hippler is ordering both sides and anyone who has worked for them on this case to preserve all of their records. So to discuss all of this drama that's going on.
How about that? He has ordered them to preserve their records. Yeah, it's called, this is the one I watched at least. I watched it last night. The Terrible Night on King Road. I'll tell you what my wife thought too. She watched it with me. So Canine Lover said, so aren't YouTube channels, I assume she means me, equally as guilty for spreading what happened in Dateline episode that many people missed. Here's what I will say. I will say that the way this works, this information is out there. The defense has filed a motion based on that information. In order for people to understand whether or not that information is going to get jurors struck, get them sequestered, make this trial take longer, or even give a continuance, we have to talk about what was in the Dateline episode. Here's what I will say. I don't know what Dateline knows. Let me tell you what I know. I have no idea what I'm about to tell you. I don't know if you guys already knew about it. There was a ton that we already knew from the Dateline episode. There was a ton of things that seemed innocuous and vague, like they had some boss at a clothing store who knew one of the girls and talked to other people who said Bryan Kohberger was creepy. It's like, what even is that? That's not even going to be admissible. I was like, and even like one of the main characters was a different friend's mom, not even one of the roommates who was there. It was, I mean, those shows, they get as much information as they can. Who the heck knows where they get it from? Maybe there wasn't a leak. He said it's likely there was a leak. There was so much inadmissible evidence coming out on there, but there's also so many people going on and saying stuff like, I knew Bryan Kohberger when he was this age and he was horrible, he was weird and blah, blah, blah. That stuff can poison a jury pool. Us talking about it can help that process because, number one, we tell you, do not believe what just because it's on Dateline. Do not believe something just because I say it here. Don't believe that Bryan Kohberger is weird because you're going to hear somebody on a YouTube channel say somebody said Bryan Kohberger is weird. We wait, and what we talk about on this YouTube channel specifically, and I'm not saying you're accusing me of anything, by the way. I'm just saying YouTube channels generally who talk about this stuff in the public, we have public discourse about this so that we can learn and understand how are we supposed to view the media? How are we supposed to view Dateline? Dateline is putting together a program they think is going to be enjoyable to watch and what they think might have happened. That doesn't matter to a jury. It shouldn't matter to a jury. And if you watched it and you're a potential juror, tell them you watched it and take it with a grain of salt because you have no idea if any of that is true or false. We have to wait and see what comes out at trial. Christy, our new member, just joined and I'm excited. Did you read or know about the book, The Night Came Falling? If so, what is your thought? I absolutely did not read that book, but I know there was a journalist author in the Dateline show. Is that the guy that wrote that book? I'm not positive. Paula Palooza, from defense side, is jurors asking questions beneficial? Why? So if jurors are watching Dateline and they think that just proved Bryan Kohberger did it, or I'll tell you what my wife thought, if they started thinking stuff like that, that is bad for the defense. But you want them to ask questions and let you know they watched because more information is always good for the lawyers in these cases. Thunder up and fire Nico, angry Mavs fan. Okay. Let me see here. Okay, so let me just give you a little rundown of some of the stuff that came out in the Dateline episode that was like, salacious or whatever. I don't think most of this is going to come out of trial. I don't know if most or if any of this is true. And I think that this shows you it was produced in a way that made Bryan Kohberger look guilty. And to not just take my word for it, I will tell you some of the stuff that was put in there. And I think that matters because if the defense is going to argue it's poisoning a jury pool, or some people in the chat have said, we think the defense leaked it, it was not good for the defense, I'll just say. And if the judge watches it and sees it, which I think he probably has done, he is not going to think it's good for the defense. And he's going to understand why the defense is pissed about this. Bryan kicked a heroin addiction and lost 100 pounds. He purchased the knife on Amazon. We know the defense has argued could have been somebody else. Was it? I don't know. Is that information going to prove to the jury? Maybe. I'm just saying the way that the Dateline show was presented. They said some things were reported here for the first time. Calls after the crimes, texts after the crimes, selfies after the crimes, photos of young women that he browsed on his phone. And multiple times they showed like blurred out college or young women, not young like children, young women on Instagram, some fully clothed, some in bikinis, some in clothes. And it's like, so every guy in college or grad school that has scrolled Instagram and looked at women, that's going to give them some kind of motive. Like, to me, there is no way that that is going to be allowed to be used against Bryan Kohberger as if he did something wrong because he was looking at girls on Instagram, right? Okay, so in case anybody's wondering, the spoiler alert about what my wife said, like half the chat is saying that right now. I'm going to keep reading some of this and then I'll tell you what my wife said. Some people they had experts on there saying he's scrolling to fulfill fantasies. He says that people like him like to feel in control, and scrolling these pictures make him feel in control. Here's one. Catalyst, the PH DJ. Yes, you heard that right. There's a guy that's a DJ. Catalyst, the PH DJ, didn't want to give out his last name for privacy concerns, but he was okay with his face and his first name and his stage name coming out. Said that he was very weird. He was invading his space. He had to tell him to back up because I got to focus on making my music. Brian Kohberger was talking and fixated on two young women in bikinis. Shocker. Husband comes over. He ignores the husband, moves to the edge where the women are. I just wonder how many guys you could say this about and try to say, look at how creepy they were. Oh, he hit on this girl, or he's following somebody on Instagram. And, but that's what they're doing here. He liked walking in the dark alone. Case closed, right? Okay. Then we get to, he's Googling Ted Bundy a lot. He is searching pornography for videos of people sleeping or passed out or under the influence of something. That's pretty bad. Dozens of photos, again, the people he looked at on Instagram. And then we heard the story about the security camera with his friend, who she called him to install it. She called him to stay at his house, but then she felt like he was creepy afterwards. And that gets to my wife's summation. She's like, I don't know. This seems pretty one-sided, but I got to be honest. Dude seems really creepy. That's what she said. He seems really creepy. And I was like, that's exactly what they want a jury to think. And I think that is going to be pretty easy to prove with Brian Kohberger. Now, there are some things in there that are absolutely very concerning. There are also things in there that I do think the prosecution is going to be able to use at some background, but I do not think they're going to be able to use everything. So what of that is new? What of it is not? What of it is true? What of it is not? Because if people are consuming this as true, I will say take every single thing we hear in every case with a grain of salt unless we hear it from the courtroom. Okay? That is important. It is important to wait and see what evidence is borne out. But I can tell from my chat friends right here, okay? This has an effect on the public, and this has an effect on people, and the defense is right. This could potentially cause a delay. And if not, they should be able to ask a ton of questions about this. Absolutely. A lot of Ted Bundy searches, a lot of searches about this Idaho case. That seems relevant to me if it's true. He was following the coverage, et cetera, et cetera. They also interviewed Rob Wood, if you remember him from the Idaho Valo Daybell trials, which I just thought that was hilarious. He did not strike me as the type of guy that wanted to go on a Dateline and do an interview. He just seemed more of like I want to be behind the scenes guy. But that was interesting. He had some tips, just treat it like a normal trial, basically. And that was basically all I was going to say about Dateline. Okay. Lack of Brian Kohberger. I think that's what BR means. Blood at the scene is a huge issue for me. I agree. And they even said in the Dateline show that he sat in some blood and then sat in another chair and there was an imprint of the blood. Need some Z's. I agree. Creepy doesn't make you guilty of this crime. Maybe the judge will subpoena Keith Morrison. That would be funny. And welcome to Barbara and all the new members. Okay. So how is the defense going to use the Dateline leak as a reason for their motion to continue? Let's take a read of some of these pages together. If you can't see it on the screen, don't worry. A lot of you listen audio only. Don't worry. We are going to read not every word of the whole 40-page motion, but the last 7 or 8 pages. Make sure you guys hit that like button if you haven't already, so that anybody following Kohberger and has been asking me to do a Kohberger update, they can come watch this Kohberger update. I don't think him looking up Ted Bundy is suspicious when he is a criminology update or major. I got to be honest. A lot of people that are in a lot of these chats and follow true crime probably have some weird search histories, right? There's a lot there that they're talking about with Brian Kohberger. How much of it is true? How much of it's going to come in a trial? That's the real question. Okay. A continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special and a forthcoming book. This case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9th, 2025, just weeks before this capital trial is set to begin, Dateline NBC aired a 2-hour episode about this case titled The Terrible Night on King Road. The program includes details and materials, including video footage, cell phone records, photographs of documents that are not publicly available through official channels. That's concerning. That is absolutely concerning. The show repeatedly emphasizes the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation and that the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. Exactly. And that is a problem. That is a problem. The defense is completely 100% legitimate to complain about it and want to look into it further. The leaked materials appear carefully curated to promote a narrative of guilt. By the way, they also put in there that it seems like Dateline knew that this stuff was not publicly available, which is why Dateline could be in some trouble, potentially, probably not. More trouble coming to the person that leaked the information. But that's also very different than a YouTube channel talking about it when Dateline has made it public and these public filings are, in fact, talking about it. As this court acknowledged in its May 15, 2025 document and records hold order, the source of the leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as witnesses. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of the witness credibility and the integrity of the state's case. Meaning, if you went behind people's back and in the shadows and leaked this information, the defense needs to know they need to cross-examine you on it during trial. The apparent leak is not only an egregious violation of the court's non-dissemination order, it enabled Dateline to gild rampant speculation with a veneer of credibility. When purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the information, it carries a heightened aura of credibility and secrecy that can deeply influence public perception. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaks framed as exclusive are perceived as uncensored truths that the public was not meant to see. By the way, there's another difference between a lot of YouTube channels, I'll just say this YouTube channel, and the way that Dateline did it. The way we talk about it, the way we couch it, the way we say not taken as true, take it with a grain of salt. There was an angle of guilt here. This insider framing enhances the material's persuasive power, suggesting that it both is authentic and revealing of the case's realities. This episode includes things such as, which by the way, another indication, they are also giving some specifics about what is in the Dateline episode. Repeated speculative assertions regarding the assailant's motives, including unfounded allegations of certain motivations, dramatic reenactments and animations depicting the alleged crime created by the show's producer without basis in evidentiary record, and very unlikely to be something that comes out at trial. Emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. The broadcast repeatedly bolstered the speculative claims through the use of so-called expert commentary, including individuals identified as law enforcement professionals and academics. These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court. while the program repeatedly emphasized their training, research, and years of experience to lend undue credibility to their conjecture. I agree. That is exactly how it was presented. This type of testimonial mimicry improperly mirrors expert witness testimony in a trial setting without the safeguard of cross-examination or evidentiary standards, effectively presenting the public with the one-sided, unvetted narrative that shapes juror perception before any admissible evidence has been presented. So just imagine, because there are some people in the chat that are watching the Karen Reed trial that absolutely think Brian Kohberger is guilty and think Karen Reed is innocent. That's fine. And that may end up being the case. I don't know. But how would you feel if you thought Karen Reed was innocent? If there were all these experts like Burgess going on there purporting himself to be an expert, but you didn't get to hear Alessi's cross. You didn't get to hear attacks on their credibility and the issues with their reports, right? That's pretty much what it was like on Dateline. While the program officially, hold on a second, let me make sure this is not important. Okay. While the program occasionally inserts disclaimers such as, we don't know what happened, these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculation descriptions of the crime. When viewers are presented with a cohesive, visually reinforced sequence of events, especially when paired with the commentary from individuals styled as experts, the overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. I agree. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on the prejudicial perception, and most viewers will leave with the impression that they have seen reliable reconstruction of the events. The Dateline special, which aired just weeks before the trial date, will not even be the last pretrial media bombshell. Best-selling crime author James Patterson has written a book about the crimes, The Idaho 4, An American Tragedy, scheduled for release on July 14th, just 16 days before jury selection is slated to begin. The blurb for the book describes Mr. Kohberger as a brilliant grad student, loner, apparent incel, and explicitly tells the reader, now you are the jury, the evidence is in. I mean, that's just horrible to do before the actual evidence is in, because I can guarantee you some stuff from that book. I shouldn't guarantee because I don't know, but I would be willing to bet that there are going to be things in that book that do not come out in evidence. The publisher boasts of unmatched access to the investigation, including interviews with local law enforcement. This suggests that the apparent Dateline leak was not the only violation of the court's non-dissemination order. That's an issue. The 6th and 14th Amendment guarantee the right to a fair trial by an impartial jury. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the current trial date. I don't think they should continue it. I wish they wouldn't. I hope the judge finds a fair and legal reason not to. But if they don't know who the leak was from and the investigation is still ongoing, and this was a very bad look and leak, they might have to. They might have to. In Shepard v. Maxwell, the Supreme Court held that the defendant was denied a fair trial due to massive, pervasive, and prejudicial publicity that the trial court failed to mitigate. The court emphasized that the trial judge's responsibility to ensure the defendant receives a fair trial free from the influence of prejudicial media coverage. The court explicitly noticed a continuance may be required to protect that defendant's rights. But where there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county not so permeated by publicity. So maybe she's arguing 2 weeks before trial, this is impossible, but if you kick it 6 months, then maybe it'll die down a little bit. I don't know. Isn't the public knowing his DNA was a match to the sheath the biggest leak of all? All this other stuff seems silly. I don't think it's silly. I think people really get a picture in their head of what they think Brian Kohberger is and who they think he is, and it just makes him look more and more guilty the more people say this type of stuff about it. And that's what the defense is trying to argue, and they're right. You should not walk in thinking somebody's guilty. Could the death penalty be off the table due to this? I don't think so, but we'll see. Peter, it's not related to Dateline, but what were your thoughts on the judge's comments about or regarding Cy Vance conspiracy theory? They were not favorable. They were not favorable. And that's interesting. This is a judge that's not just going to pull punches. That's why I think the defense leaked it. They've been trying to get this extended in so many ways and failed. This would be absolute legal malpractice if they leak stuff to make him look more guilty. I really don't think it was them. I could be wrong. Now, it could be inadvertent. Somehow somebody's secretary's son showed up for lunch one day at the office and took pictures and gave it to Dateline. I don't know. We've heard of things like that happening before. The Supreme Court has likewise recognized that the passage of time can significantly reduce the taint of media exposure. There's a case involving extensive coverage of a confession. A delay between the media saturation and trial reduced its prejudicial impact. So to me, that is an option for this court. The court has recognized that while the pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, the trial judge has a major responsibility. The measures a judge takes or fails to take to mitigate the effects of the pretrial publicity may as well determine whether the defendant receives a trial consistent with the requirements of due process. The timing of the trial is a key factor in ensuring juror impartiality, as emotional intensity and memory of prejudicial material tend to fade over time. Some people's memories get better. Social science research supports this position. A comprehensive meta-analysis found that pretrial publicity significantly increases the likelihood of conviction, but that the effect is diminished when there is a temporal delay between media exposure and trial. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. I agree with that. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary. All time to air just weeks before trial, when juror impressions are most vulnerable and voir dire least equipped to neutralize such deep-seated bias. I agree. It's like I saw something 2 years ago. I don't really remember what it was about, as opposed to I saw something last week. The forthcoming book by James Patterson, which will arrive in the hands of potential jurors just 2 weeks before voir dire begins, promises to set off a new round of inflammatory, negative coverage and to deepen the pervasive bias against Mr. Kohberger on the eve of trial. The court has already acknowledged that the Dateline special exposes a likely violation of the non-dissemination order, and Mr. Patterson's purported unmatched access to sources, including local law enforcement, suggests that multiple unauthorized disclosures have occurred. Depending on the results of the investigation into the leaks and a continuance may be inadequate. Once the sources of the leaks are identified and the full extent of the misconduct revealed, the violations could warrant remedies more serious than delay, meaning dismissal of the charges is what she means, but not going to happen. Continuance, I think, is possible. Dismissal, not happening. Depending on the results of the investigation into the leaks, a continuance may be inadequate. Okay, I already read that. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside. And we know the judge is pissed about this. We know the judge thinks this is serious. So that's why this might hold some water. Only then, a continuance is essential to allow extremely prejudicial and to give the court and the defense time to fully investigate and address the scope of the violations. Only then can the conditions necessary for selecting an impartial jury and ensuring a fair trial under the 6th and 14th Amendment be meaningfully restored. Reversal is more likely than not in any case resulting in a death sentence. So why does she throw this paragraph in here? This is something that tells the judge, hey, judge, you don't want this overturned. We don't want to have to do this again. If you rule the wrong way, guess what? We're going to appeal and we could get it reversed. Azam, Peter, thanks for a 2 a.m. live so I can watch until the end of the episode and go back to sleep before getting ready for school. Less than 10K to 500,000. It's truly wild, Azam, truly wild. So statistically, almost 2/3 of death penalty cases are eventually overturned due to errors, often many years or decades after the initial conviction. A frequent cause is reversal on ineffectiveness grounds due to the lack of an exhaustive investigation and complete presentation to the sentencer. Hundreds of cases could serve as examples, but for brevity, the following are, and she lists a bunch of cases. Mr. Kohberger deserves a fair trial from the outset to prevent an arbitrary or wrongful conviction and potential death sentence. These cases underscored the critical importance of thorough investigation before trial. This diligence is essential to avoid the costly and time-consuming process of reversing a conviction and death sentence years or even decades later and then having to try the case again. And she's right. And it's not just for the media attention. It's also for not giving lawyers the opportunity to prep for the sentencing phase, to prep for that penalty phase. Christy Allison, in my opinion, info about mutilating Ethan's leg was the biggest update shock for me. I definitely had not heard that before. I agree. Christine, Peter, been following you since Karen Reed trial 1, and this is my first super chat. Whatever happened with the affidavit from the cell expert accusing the prosecution of not disclosing all cell data? I don't know if they had some of that stuff done behind closed doors, but it does not seem like the judge agreed with that expert. That's as much as I've seen on it. I haven't done a deep dive on it. After Karen Reed's over, my guess is we're going to go deep into Brian Kohberger, unless it gets kicked to next year, maybe. Amanda A., I've searched similar things. I think it's totally something that raises flags. Brian searching this crime and his own name, if the time of the Google search of the crime was before it was public knowledge, big red flag. I agree. There's a lot of details and context we need though, right? Fishy colors, DL, irresponsible Peter. What questions will be asked prospective jurors by lawyers? Did you see anything on Dateline, Netflix, HBO Max, whatever? Have you read any books like this book, that book, that book? Do you know anybody that does? Have any of your friends talked about it? Do you subscribe to Peacock or YouTube TV or whatever? The picture screenings his phone baffles me. Yeah. All right, we're almost done here. A continuance is reasonable and necessary under the circumstances. While there is no mechanical test for determining whether a continuance should be granted, the trial court cannot deny a continuance based on a myopic insistence upon expeditiousness in the face of a justifiable request for delay. In determining whether denial of a continuance request resulted in a violation of due process, the reviewing court looks to the circumstances of the case, particularly the reasons presented to the trial judge at the time requested was denied. This request is not made lightly. Defense counsel has worked around the clock actively preparing for trial since appointment of this case, filed all motions in a timely manner, complied with expert disclosure deadlines, and had expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of the necessary discovery, meaningfully respond to all the state's amended expert disclosures, blaming the state's always a good way, and incorporate the information into an effective defense and finish critical sentencing phase investigations. While prompt administration of justice is important to both the state and Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. And because the majority of cases ending in death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure that Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts, not forced haste. And that's what we want. We want a fair trial. We want a proper trial. We want a verdict we can believe in and agree with, and that will not get overturned regardless of what that verdict is. If it's possible, it's the families leaking info. Is there any recourse for the defense? No, it doesn't seem like it's coming from the families. Valo Doc came out before the trial. I remember. And Murdaugh. Media is the thing in every case. People outside the prosecution have the right to talk about their own experience. So is it more of a matter of media ethics? I think it's a matter of who gave them the exclusive info that was not public. I think if they did a documentary on the public info, I still would have hated it and wish they wouldn't have done it because it's probably going to affect the trial. I don't think the judge would say anything about it. And the defense may still argue it. But if somebody on the prosecution team really leaked info, that could be a major problem that the defense is going to highlight. I just got the hiccups. Horrible time for that. Thank you, Lynn, for the super chat. No typos. His pictures were creepy. My search history is Gacy. Deep dive with no Karen Reed for 5 days. All right. Perfect time to end because these hiccups don't look like they're going away. I appreciate you guys so much for being here. Please hit the like button. Make sure you're subscribed because we've got a lot of Karen Reed content coming over the weekend and tomorrow. Wouldn't a delay just mean more time for books, docs, speculation to come out? Possibly. It would be never ending. Appreciate your coverage. That is possible, but we know right now that there's a Dateline episode and a book coming out just weeks before trial. In the future, maybe it won't be there. It could, but maybe not. Love you all. Kohberger update done and in the books. But let me know what questions you have and stuff that comes up with Kohberger. Tag me in it. Send me it. Oh, I'm annoying myself with these. I can't imagine how annoyed you guys are. You're the best. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.